Good afternoon, sir. Are you Mr. Kenneth Martin?
Good afternoon, sir. Yes, I am.
Very good. We're pleased to have you here today. You've had the benefit of watching attorneys present their case, argue their case while you were waiting for your case to be called. You have, and the attorney opposing you have 15 minutes each to present your arguments. You have the right to reserve 5 of those or less, 15 minutes if you want to rebut, to respond to what the attorney says. Do you wish to save any time?
Yes, Your Honor. I would like to set aside 5 minutes for
5 minutes, very good. Then the clock will be set for 10 minutes, and that'll be your initial statement. The floor is yours.
Yes, Your Honor. So I'm Kenneth Martin, the appellant in this case. May it please the court, my name is Kenneth Martin, the appellant. This is an appeal from the trial court's denial of a Tennessee Rule of Civil Procedure Rule 60.023, the judgment is void motion. The issue underlying is that because the trial court proceeded to a final judgment without a complaint ever being filed in this case, and without the appellant ever being served with a summons and complaint in the case, violating my foundational principles of due process and the Tennessee Rules of Civil Procedure. According to the Tennessee Rules of Civil Procedure, Rule 3, it says all civil actions are commenced by filing a complaint with the clerk of the court. In this case, there was no complaint filed with the clerk of the court, so the case should have never proceeded in court. There's no record that shows that a complaint was filed with the court, so without a complaint being filed, there's nothing that the judge, had subject matter to rule over, I feel, in this case, Your Honor. And so, in addition to that, Tennessee Rules of Civil Procedure Rule 4.05 requires that Mr. Martin be served with a summons to establish personal jurisdiction. There was no summons that I was served with for the case, Your Honor. So the court lacked personal jurisdiction to make any orders or judgments against me in the case. And without service of process, the court lacked personal jurisdiction pursuant to Tennessee Rules of Civil Procedure 12.02, lack of jurisdiction over the person to enter any valid judgments or orders against Mr. Martin. In addition to that, Tennessee Rules of Civil Procedure Rule 4.011, this rule says that upon the filing of a complaint, the clerk of the court shall promptly issue the required summons and causet. And in this case, Heather L. Moore, without the filing of a complaint, issued summons in this case. As a result, Heather L. Moore had no legal justification to issue the summons in this case because there was no complaint filed with the court. And then the state of Tennessee, XRL, and Ms. Barrett failed to serve the summons upon me for the case, Your Honor. So I was not legally before the court in this case. Pursuant to Tennessee Rules of Civil Procedure Rule 4.012, Mr. Martin was never served with the summons for the February 6th case. This rule says the process server must be identified by name and address on the return. There is no record of a process server being identified by name and address for a summons and complaint for the case on February 6th, Your Honor. And then under Tennessee Rules of Civil Procedure Rule 4.02, it outlines all the requirements that must be met for a summons. And nowhere in the record does it show that a summons meets those legal requirements that were served upon me, Your Honor. And so those requirements are that there was, Mr. Martin was never issued a summons in the name of the state of Tennessee for the case. Mr. Martin was never issued a summons that was dated and signed by the clerk of the court for the case. Mr. Martin was never received a summons that contained the name of the court and the county. Mr. Martin never received a summons with the title of the action listed as a summons that required Mr. Martin to appear in court on February 6th. Mr. Martin never received a summons that was directed to him for the February 6th case. And Mr. Martin never received a summons that stated the time within which these rules required the defendant myself to appear and defend, Your Honor. Consequently, Ms. Barrett in the state of Tennessee XRL failed to serve Mr. Martin with the summons that meet the legal requirements of Tennessee Rules of Civil Procedure 4.02. All right. Tennessee Rules of Civil Procedure Rule 4.031, Your Honor, says that the person serving the summons shall promptly make proof of service to the court and shall identify the person served and shall describe the manner of service. There's no record of any person promptly making proof of service to the court and identifying Mr. Martin as the person served or described the manner of which Mr. Martin was served for the February 6th case, Your Honor. And then, what is this? Under Tennessee Rules of Civil Procedure Rule 4.032, it says that the person making the service shall endorse over his or her signature on the original summons the date of mailing a certified copy of the summons and a copy of the complaint to the defendant and the date of receipt from the defendant. There is no record that the person making service endorsed over his or her signature on the original summons, Your Honor, the date of mailing a certified copy of the summons and a copy of the complaint to Mr. Martin, and the date of the receipt of return from Mr. Martin. As a result, Mrs. Barrett and the State of Tennessee ex rel have failed to meet the legal requirements pursuant to Tennessee Rules of Civil Procedure Rule 4.032. All right. Under Tennessee's Rule of Civil Procedure Rule 4.05, this rule requires that for service of process to be met, that I be served with a summons and complaint. Because I was never served with a summons and complaint, service of process was not met in this case, Your Honor. And Ms. Barrett and them failed to meet the service of process requirements pursuant to that rule, Your Honor. And so Mr. Martin was never properly served with the summons and complaint as legally required pursuant to Tennessee Rules of Civil Procedure Rule 4.052, which clearly states that the service of process pursuant to this rule 4.05 shall include a copy of the summons and of the complaint. Therefore, Mr. Martin was not properly before the court. For that reason, this is insufficiency of service of process pursuant to Tennessee Rules of Civil Procedure 12.025, Your Honor. As a result, the Chancery Court of Montgomery County, Tennessee at Clarksville failed to acquire personal jurisdiction over Mr. Martin before making any orders or judgments against Mr. Martin. Therefore, the Chancery Court lacked personal jurisdiction pursuant to Tennessee Rules of Civil Procedure 12.022, lack of jurisdiction over the person to enter any judgments or orders against Mr. Martin, Your Honor. So, conclusion for this, Your Honor, would be that no summons and complaint were served. The court lacked personal jurisdiction over Mr. Martin. Consequently, the judgment should be void under Tennessee Rules of Civil Procedure Rule 60.023. And that's what I have, Your Honor.
All right. Thank you, Mr. Martin. We'll hear from you again after we hear from the attorney.
Yes, Your Honor.
Good afternoon.
Good afternoon, Your Honor. Rebecca Garman from the Montgomery County Bar. I represent Magistrate Travis and the Clerk and Master Heather Moore. Mr. Barnett represents the State of Tennessee defendants, and I will ask that the court allow him 7 minutes. I'm going to take the first 8 minutes, and
Very
he'll
good.
argue for the final
All right.
7
We'll
minutes.
set your clock for 8 minutes. Thank you.
Thank you, Your Honor. I want to address first a brief overview of the facts in this case. Appellant Mr. Martin just talked a lot about a complaint and a summons, and I want the court to be aware that all of those things that he was talking about are from a completely different case. They're not the case that we're here on today, but they are related, so I would like to give a brief overview of this prior case. In March of 2018, plaintiff appellant filed a petition or a complaint for divorce against defendant Natasha Barnett. That divorce was finalized in May of 2019, and that was the end of the divorce at that time. However, in January of 2022, a petition to set child support was filed on behalf of by the State of Tennessee on behalf of Ms. Barnett. Several summonses were issued for that petition to set child support. That was appropriate. Many of those summonses were returned as unable to be served, but in November of 2022, a new summons was issued to Mr. Martin, and it was served, I believe, November 12 of 2022. That document, the return of service, along with an affidavit from the private process server, is in the record. It's in volume 4 of the record. It starts on page 439 and goes from there. But there is a summons that was issued appropriately on the petition to set child support. That was issued in November of 2022, was served in person on Mr. Barnett in November of 2022 as well. There was a return of service filed. The affidavit from the private process server is listed on that document. A description of the individual he served, as well as his name and location, are also listed. So all of that is proper and appropriate. After that, the trial for the petition was set for hearing on February 6th of 2023. Mr. Martin appeared at that trial. I believe he appeared in person, and it was ruled over by Magistrate Judge Travis. Mr. Martin presented proof, as far as we can tell, and fully participated in that hearing without any indication that he was not properly before the court. It is our position that he appeared at that February 2023 trial as a general appearance. Magistrate Travis then issued her findings and recommendations, where she established a monthly child support obligation for Mr. Martin, as well as child support arrearages. On February 14 of 2023, an order confirming those findings and the recommendations was entered by the chancellor. That will be the final order establishing the child support obligation and the arrearages. 30 days passed, there was no appeal. In fact, there has never been an appeal of that order. In January of 2024, a new petition to modify the child support was filed by the state of Tennessee on behalf of Mr. Martin. That matter was set for a hearing on June 3 of 2024, and at that time, Mr. Martin asked that the petition be dismissed. The petition was dismissed. Ironically, though, that same day, June 3 of 2024, Mr. Martin turned around and filed this lawsuit that we're here on today. So there are two separate lawsuits, and the lawsuit Mr. Martin has talked about during his argument were the previous divorce file and child support, which was filed in Montgomery County Chancery Court and had a docket number of DI-18-186. This lawsuit that we're here on today is a completely different lawsuit. It is candidly difficult to understand the precise claims that he's making, although it seems to be a collateral attack on the child support obligation that he has been entered. On behalf of Magistrate Travis, we will say that no summons has ever been issued to her, so we contend she is not before the court. Only a limited appearance was submitted on her behalf, along with the Rule 12 motion. I did not hear any discussion about Magistrate Travis at all from Mr. Martin during his oral argument, so I'm not even clear if he's still attempting to assert a claim against her. But if he is, we contend that she's not properly before the court because no summons was issued. So there's insufficient process and also insufficient service of process. Alternatively, she was the child support magistrate at the time. Any activities that she performed in this case for which Mr. Martin may complain, she is immune from those as judicial duties. Moving on to the clerk and master, we contend she is also immune because any issues relating to an issuance of a summons or anything with paperwork in the pleadings are part of her quasi-judicial duties, and she is immune from those. All I heard Mr. Martin mention today about the clerk and master, Heather Moore, is that she issued a summons without a complaint. Candidly, that's mistaken. There was a petition to set child support, which is a proper petition, which was filed in the divorce and child support case. That is a complaint or petition, a proper initiating pleading in this case. The clerk and master, at the request of the state of Tennessee, who had submitted the petition, issued a summons. In fact, issued several summonses because the first were not properly served on Mr. Martin. But there was a summons that was issued in November of 2022 and properly served on him later that month. So none of those all of those activities that the clerk and master Moore performed were quasi-judicial functions for which she is entitled to immunity. I also want to address a few things that were addressed in Mr. Martin's brief, although I did not hear about them today. There was a significant discussion in the brief and at the trial court level about the clerk and master not signing some of the pleadings, some of the summonses, and instead the deputy clerks were signing those. That is absolutely appropriate under the law, and we have cited those provisions in our brief. The second dealt with a requirement under Federal Rule of Civil Procedure 4, which required the inclusion or the affixation of a court seal. There is no such requirement of putting a court seal on pleadings in the Tennessee Rules of Civil Procedure, and the Federal Rules of Civil Procedure do not apply in this case. We have outlined for your honors and for this court the supremacy clause allegations that Mr. Martin made. I did not hear him discuss those today, so we will rely on our brief on those options and contend that the trial court was correct, that the Rule 12 motions to dismiss Magistrate Travis and Clerk and Master Moore were appropriate and should be affirmed on appeal. I will say, and just want to reiterate, that the child support judgment is not void, as Mr. Martin argues, because there was a proper petition to set child support. There was a summons that was issued for that petition, and that summons was properly served upon Mr. Martin in person in November of 2022. But regardless, if there was some issue with service of process, he appeared and has waived any service of process issue by a general appearance and participation at the trial court level in February of 2023.
All right, thank you very much. Good afternoon.
Good afternoon, Your Honor. My name is Wade Barnett from the Tennessee Attorney General's Office, and I represent the state defendants, the state of Tennessee, the Child Support Office of Montgomery County, and the Chancery Court of Montgomery County. Just for purposes of clarification, General Scrimeti and General Nash were named as parties on appeal. They were never named parties at the trial court level, but just to clarify that for the record. As Ms. Garmons stated, this case is an impermissible collateral attack on a child support judgment. In the state defendants' arguments, there's two arguments today. First, the state defendants would argue that Mr. Martin has waived all challenge to the trial court's judgment on appeal due to deficient briefing. Rules of appellate procedure and this court's rules outlines certain requirements for briefing. Mr. Martin did not comply with those. For example, in his statement of issues, he doesn't address many of the grounds that the trial court relied on in dismissing the amended complaint, including sovereign immunity, insufficient service of process, relief under Rule 60, and the statute of limitations. His statement of facts and statement of the case contain legal argument, and he does not cite to the record whatsoever. Yes, he is a pro se litigant, but pro se litigants have some leeway, but they still have to follow the same substantive and procedural requirements as attorneys, and that was not done so here. So the state defendants would argue that all challenges to the trial court's judgment here have been waived. In the alternative, the state defendants asked this court to affirm the trial court's judgment. First, the state defendants have sovereign immunity. Mr. Martin has asked for $10 million in damages. Under Tennessee law, the party cannot seek monetary damages from the state unless the state consents or waives sovereign immunity. That has not been done so here. And plaintiff does not cite any applicable authority that waives sovereign immunity. There's also insufficient service of process. Under the rules of civil procedure, in order to serve the state, you have to serve the Attorney General or to an Assistant Attorney General. In this case, Mr. Martin served an Assistant District Attorney General. He argues that that is proper. It's not. This court has held that in order to effectuate proper service, there has to be strict compliance with Rule 4. And Rule 4 explicitly states it has to be served on the Attorney General or an Assistant Attorney General, someone like in my position. Likewise, the trial court did not err in finding that Mr. Martin has failed to state a claim. Again, Mr. Martin has tried to issue a collateral attack on the child support judgment based off of lack of personal jurisdiction. He argues that there was no summons, but as Ms. Garman mentioned, there was summons. There was a petition to set support. There was a process server that served him back in November of 2022. And even then, as Ms. Garman mentioned, Mr. Martin made an in-person appearance on February 6th here in Montgomery County. The trial court's order notes that he attended, and he actively participated. He answered questions. He did not raise any applicable Rule 12 defenses at that time. He did not file a notice of appeal. And when the state filed a petition to modify on his behalf, he dismissed that before filing the current complaint before this court. Also, there's a statute of limitations. Constitutional torts have a 1-year statute of limitations in Tennessee. The child support order was entered in February of 2023. His wages were first garnished in April of 23, but he didn't file his complaint until June of 2024, over a year later. So there are a number of different arguments that Mr. Martin has made in his brief regarding Rule 60, equal protection due process claims. However, as stated earlier, he's actively participated in the child support proceedings, and I would rely on the brief for those issues, and if the court has any questions for me, I'm happy to answer those, but that would conclude my argument.
All right, hearing none, thank you, General.
Thank you, Your Honor.
Mr. Martin, you have the opportunity to respond or make your final argument.
All right, Your Honor, the first thing that I would like to address would be, I'm sorry, I don't know your name, ma'am, but the lady over there stated that—
Ms. Garman.
Ms. Garman, yes, ma'am, sorry. That Mr. Martin was served on November of 2022. Well, that is correct, except for what she failed to mention was that summons that I was served with was for a completely different case that was, I believe, on December 5th of 2022. I never appeared in that case. I don't know what happened in that case because it clearly states on that summons that it's a no in-person appearance on that summons. And then from my understanding of the law, excuse my ignorance of the law, Your Honor, but from my understanding of reading several court cases is that if a court lacks personal jurisdiction over a person and a case is proven to be void from the face of the record, which in this case would be because I was never served with a summons or a complaint, the court never had personal jurisdiction over me to enter any judgments or orders against me in the case, that I legally would be able to attack this case. To address Judge Travis, I never had Judge Travis on this case, so I'm not sure why they keep bringing her up for this case. She was mentioned in my original complaint, but I never served her or anything for her to be a part of this case. Then further—
You didn't intend Judge Travis to be a defendant in this case?
No, Your Honor. I never served her or anything. I just made mention of her in the complaint, Your Honor. They mentioned the petition to set support. All right, nowhere in Tennessee Rules of Civil Procedure, Rule 4.05, does it say that a petition to set support meets the legal requirements of Mr. Martin being served with a summons and complaint. The petition to set support fails to address any violations of laws, of Ms. Barrett's rights, or anything that I did to be brought to court. So I think that all in itself fails to meet the legal requirements of what a complaint is supposed to be before the court. Nowhere in the petition to set support does it allege that I violated any laws or rights. And then without a summons and complaint, I am not required legally to file an answer until after I am served with a summons and complaint pursuant to Tennessee Rules of Civil Procedure Rule 12.01 says a defendant shall serve an answer within 30 days after the service of the summons and complaint upon him. Because I was never served with the summons and complaint, I'm legally not required to file a answer, Your Honor. And then to the gentleman, I'm sorry, I don't know your name, sir.
General Barnett.
But to General Barnett's statement about the law saying about the Attorney General, that have to serve the Attorney General, from what I've read in the law, Your Honor, it states any Assistant Attorney General. It doesn't specify in the law that it has to be a state or district Attorney General. It clearly says any Attorney General. So from my interpretation of that law, it's the requirement to serve Assistant Attorney General was met. And then pursuant to rules, Tennessee Rules of Civil Procedure, Rule 60.023, the judgment is void does not have a time limitation on which a person is bound by to challenge a void judgment, Your Honor. And that's all I have, Your Honor.
All right. Thank you, Mr. Martin, for your argument. Your case will be taken under advisement, and a written opinion will be prepared, and the clerk of the court will forward that to you, to the address that you have provided to the court.
Yes, Your
All right, and thank you, Ms. Garman and General Barnett. That concludes the docket.